We talked about works of authorship. Now we have to talk about originality, the second component. We need original works of authorship that are fixed in a tangible medium of expression. We're going to be talking about what constitutes original. And this requirement has two effects. One is that the work that lacks originality is not copyrighted. Things like customer lists, mechanically produced copy of an 18th century map, for instance, white pages in a telephone book, they lack originality. There's nothing to them because only original creative expression is allowed to be copyrighted. And I should distinguish those examples to something like a clumsy drawing. Remember my painting? My painting is entitled to copyright protection. If I sat here and strummed out a song and recorded it up onto my computer, that is totally copyrightable. I can bang out one of those novels in 30 days, right? In November, there's a novel writing kind of, I don't want to call it a contest, not a contest, where you try and write a novel in 30 days. It's not going to be the best novel, but it will be a protected work. So the threshold isn't very big, but there still has to be some originality. And number 2 point, non-original elements of a work are also not protected, like facts. Remember, we talked about those things, facts. The fact itself, the fact that George Washington was our first president, is a fact. That is not copyrightable. What is copyrightable is if I wrote a book of interesting facts and I listed them all in a book. Now my book would be copyrighted, but the facts and the elements contained therein, not copyrighted. A history book, right? A book on the Kennedy assassination. Those are facts. But the book qualifies as an original work of authorship. So let's talk about this. What works should qualify for protection? And the courts have defined originality, and the test to set the standard for originality has been determined. And we're going to start with a very old case. That started our originality test. What is originality? And the Alfred Bell case is from 1951. It is from a federal court in New York, our appeals court, the Second Circuit. I'll give you a little background about that. This case is in the book, by the way. If you want to look more into it, read more into it, I'm going to give you the basic gist. So Bell, our plaintiff, Alfred Bell, he was making these mezzotint photographs, as you can see on the right-hand side. He's an artist that traces the photograph of works, and they engrave the tracing onto a printing plate, and then the printing plate makes reproductions. And that could be easily be done or reprinted in books, okay? So the original is in the public domain, okay? So we see our original, we see the other. They look quite the same, slightly different, maybe a little enhanced color. You guys take a look and determine what you think as I give you the rest of the facts. The defendant began reprinting some of Bell's works and pictures, so Bell sues for copyright infringement. And the defendant's argument was that Bell couldn't possibly have a copyright because his works are merely the faithful reproductions of the other work, which is in the public domain. So therefore, there's not an original work of authorship. And under the statute, as we just read, it requires a work to be original. even though I'll remind you this case is 1951, and the statute we're working with now wasn't in play, the 1976 copyright statute. However, the previous one did have this requirement of originality, so it did require originality. And the example that the defendant used was the Mona Lisa. The Mona Lisa is in the public domain. How could you possibly get a copyright on the Mona Lisa? And the trial court, which is the first court this case had to come into, found that every engraver would engrave the mezzotint slightly different. And those subtle differences were enough to meet the originality requirement. So the trial court found in favor of Bell, and of course the unhappy person can appeal, which is exactly what the defendant did here. And the appellate court found that the term original should be read to mean owes its origin. The work owes its origin to a particular author, and not that the work was startling, novel, or unusual, or marked departure from the past, was another way they explained it. The court noted that maps are copyrightable, and ideally all maps should be exactly the same to be accurate. The court noted that while you can't copyright a work in the public domain, you can copyright a translation of the work in the public domain, and that is exactly what Bell did here. Despite these similarities, there was an artistic interpretation of a public domain work. And as you can see, there's not a huge difference between the two. So it doesn't have to be novel or unusual, just that the work owes its origin to a particular author. So this was the first case that addressed originality. It still is used today, along with the next case that went all the way up to the Supreme Court that we're going to talk about here next. This is the standard. Now, we went from 1951 to 1991. Rural Telephone is our defendant. Give you a little background, which set the standard that you see before you. So this is our facts here. We have Rural Telephone Service Company, who initially is the plaintiff. They provide telephone service to several communities. And due to a state regulation, it's required to issue an annual telephone directory. So it published a directory consisting of white and yellow pages. The yellow pages have advertisements that generate revenue. The defendant, the Feist, I think I say it, the Feist Publications, is also a publishing company whose directory covers a larger range than a typical directory. And they distribute their telephone book free of charge, and they also generate revenue through the advertising in yellow pages. Plaintiff refused to give them, the Rural Telephone Company refused to give the Feist a license to them for the phone numbers in the area. So guess what happened? They used them anyway. They used them without the consent, and Rural Telephone sued. And what becomes of that? This case goes all the way up to the Supreme Court, and the Supreme Court said that, well, what they set forth was this test, that a work is independently created. If you have a work that is independently created by the author and work possesses at least some minimal degree of creativity, the work does not have to be innovative or surprising, only that it be more than so mechanical or routine as to require no creativity whatsoever. So, concerned that the extent of the copyright protection that Rural telephone directory had in the white pages. So what does that consist of? The telephone directory in white pages? Names of subscribers. They're listed in alphabetical order relative to their towns and their telephone numbers. And what do you think about that? Is that original? That information existed way before Rural ever gathered it and published it. They set these names up in a list. Is it really novel? Does it have to be novel? Is there some sort of creativity? The problems for Rural is that they didn't have copyright in that raw data. There's no copyright in the selection or arrangement of data. Alphabetical order, A, B, C, D. There's no creativity there. There's no copyright in that. What if they selected to do it a different way? What if they decided to arrange it in another way? Would it ultimately result in some creativity? The court held in favor of Fies Publications. Rural Telephone lost their copyright infringement. The court said that your telephone book, that information, those pages of people's names in alphabetical order with their phone number does not meet number 2. You may have a work that's independently created, but you don't have number 2. The work doesn't possess at least some minimal degree of creativity. So this is the test. Facts are not copyrightable. But as we will discuss in a little bit, a compilation of facts, actually we already kind of sort of covered it, but we're going to talk about it in more detail. But a compilation of facts may be if selection, coordination, or arrangement of facts reflects some necessary degree of creativity. So, this is our originality standard. This is the standard that courts will use to determine whether or not a work is original. So we're going to be using this. We're going to be using works of authorship. Is it a work of authorship? Is it original? Is it fixed when we get to that element? So let's talk about some examples. This is our point 1, independent creation. This is the first point that comes out of that case. Copyright protection only in elements of the work that's created, okay? No protection in facts or other phenomena, even if the person who discovered them first. So discovery is not creation. Discovery is not creation. So let me take for an example. A biologist discovers that elephants can understand sign language. Can a biologist claim copyright in that information? No. Why? Because discovery is not creation. Even if she is the first to discover that fact, because that's a fact. Elephants can understand sign language. That's not creativity. Even if she publishes that fact is still not copyrightable. If she writes an entire book about her study of elephants and how she learned about how they understood sign language, now that could be an original work of authorship. What if a biologist weighs every elephant in zoos in every country and records the data? Is that information copyrightable? No, those are facts. Doesn't matter that she put in all that work. We'll talk about sweat to the brow in a little bit. She has to make or be the originator, not discover and record. Okay, so facts, what constitutes facts? Scientific information, historical information, biographical information, news of the day. You find a new flower, you find a gem, any geological information. No copyrights. But what if the works contain facts? Can it be copyrightable? I've been alluding to this already. The Kelley Blue Book. What is it? It's a listing of transactions of cars sold right? It lists their values. You want to see what your car is worth, you go to the Kelley Blue Book, type in information. Is that protected? They don't actually report the actual transactions, right? They're more estimates of values. The estimates based on the actual prices of cars sold. They require some consideration of other factors, right? Some other factors that might be original elements. Kelley Blue Book is something that is considered original. A book, and I already gave you an example about the book about John F. Kennedy. If you write a book about John F. Kennedy's presidency, the facts contained therein are not copyrightable. I could take that information right out and do it in my own book. I can't do it exactly like your book because your book itself is copyrightable. But if I make a different version, set out differently, then it will be copyrightable. Okay? All right, let's see. How about this for an example? Anna writes a novel about using plots and characters of Hamlet. Can she bar other people from using the plot and characters of Hamlet? Hamlet's in the public domain. So she writes a novel that uses the plots and characters of Hamlet. She can do that, right? We just talked about using something that's in the public domain and make it your own original work. It doesn't have to be novel. Can she bar anyone? No. You can also go and use the plot and characters of Hamlet. Hannah writes a historical novel about George Washington. Her copyright does not cover the historical facts. I think I've kind of beaten that one up, right? What about a homeowner discovers an unpublished short story in a dusty cabinet? And then they go and publish it in their own name. Well, that short story is certainly copyrightable. It's original, but it's not the homeowner's. Homeowner would be what? Infringing on the copyright. They discover an unpublished short story and then publish it in their own name. That's not theirs to do. How about a transcript by a court reporter? Court reporter is one of those people who sits in the courtroom and takes everything down, but they're also the one that not only are they taking it down and recording it to some sort of tangible medium, they also print it off too for distribution. You have to pay for copies. Do they own a copyright in that? No, it's not original. All that information is coming from facts that are being presented in a courtroom. All right. So that was element number 1 for independent creation. You have to have independent creation. Second element is novelty. Right? There has to be some sense of novelty in our element number 2. Some minimal degree of creativity. Creativity, that's our word. Some minimal degree. I'm using air quotes. All right, does the work have to be novel? Alfred Bell case said no. The Supreme Court used the minimal degree. Okay? So you need not be unique or different from preceding works. You just saw that in the Alfred Bell case. How is this different from patents? Patents, you need novelty. That novelty requirement, if an inventor invents a machine and unbeknownst to him or her, it's a machine just like one that's already in public use, you're not entitled to a patent. It's not novel. Here it doesn't matter, as long as the author created it. I have exercises up here, not jumping jacks. I probably made that joke already. You'll find in this week's assignment, usually I would do these in class. They're going to be part of assignments. Similar fact patterns as I was going through to see if you can distinguish between the elements for originality. and what constitutes minimum creativity and such. But I want to show you the next slide. I want to discuss another example of pre-existing designs. These are in the public domain, just like the Alfred Bell photographs with the slight variation on it. It was considered copyrightable. The origin is connected to the author. I want to expand on this a little bit more with regards to creativity. So this design here is in the public domain. We can take it and use it, manipulate it, copy it, however we see fit. Does it look familiar? So Mike Tyson's tattoo, it's been said that it's a pre-existing design or taken from that design pattern that we just saw, or a type of design pattern. If the tattoo artist made an exact copy of the design we just saw, there would be no copyright. But here you can see it's got some adaptation to the design. So the question becomes whether or not this tattoo is copyrightable. It's a work of authorship by a tattoo artist. Mike Tyson had some say in his tattoo, but there was actually an agreement between the tattoo artist and Mike Tyson that the tattoo artist would own the copyright in that tattoo. So then, here comes along the movie Hangover 2. And I haven't seen Hangover 2. I saw the first one. I didn't need to see the second one. Anyway, so, tattoo. Copy. Is it an exact copy? It's pretty darn close. That's for sure. Well, you can imagine that the tattoo artist did bring a lawsuit against, I think it was Warner, the movie company that did Hangover, stating that they violated his copyright by doing this. And, is the suggestion, is it coincidence? That was the argument by the movie company. We're going to talk more about this when we talk about infringement. But for purposes of this discussion, we're talking about originality. Is Mike Tyson's tattoo even original? That would give the tattoo artist the copyright? Would it meet that test? It probably meets number one, is there some minimal degree of creativity here? And I can't jump back to the other photo, but if you jump back to the other photo, there has been some manipulation, and it would probably clear the threshold of the rural telephone bookcase. So those are things you got to look at when you're looking at something so close, right? We're going to talk about whether or not this constitutes infringement. When we talk about infringement, we'll revisit that. Right now we're talking about originality. And one more case on originality, and then I'll let you try some of those exercises. Taylor Swift was sued 2018 by songwriters Sean Hall and Nathan Butler. They claimed that she took the player's gonna play and the hater's gonna hate verse in the chorus of her Shake It Off song. They took it from their song, Play Is Gonna Play, which Hall and Butler wrote for a girl group called 3LW back in 2001. So that's what we're talking about here. This phrase, player's gonna play and the hater's gonna hate, that's in the chorus of Shake It Off. And the original, or at least Sean and Nathan are saying she took it from their song, Play Is Gonna Play. So with little that you know about copyright right now, is that copyrightable? Is that something that might be a short phrase? Is that common language? Hall and Butler conceded the ideas of players playing and haters hating were already firmly rooted in pop culture when their song was released. But they contended that putting these ideas together into a catchy phrase was creative and original at the time they did it. Okay. What do you think? Taylor Swift's team is arguing that the phrase is within the public domain and can be freely used. It's not protected, it's just words. Just a phrase. Phrases aren't protected. And the case came down to whether the lyrics were creative and original enough to be eligible for copyright protection. And the court, now this is what let me give you a little procedural information. So they filed a case. If you remember our discussion on civil cases, the plaintiff brings the case to a trial court, and in this case it was federal court in California, low trial court and federal court, district court in California, and they have to say what they're claiming, copyright infringement, and then they serve Taylor Swift, and then she has an opportunity to respond. We're at the very beginning stages of this case, and her response is, "Judge, you need to dismiss this. This is bogus. This isn't even copyright protectable." So she's out of the gate saying, "There's no case here." That's her response. There's no case here. And a judge has to decide that right now, whether or not they can even claim what they're claiming. And that court dismissed the case and said, yeah, a song's lyrics can be protected only if they go beyond what a court refers to as the banal or trivial. So in this case, the court said the infringed lyrics are short phrases that lack the originality and creativity required for copyright protection. So the lower court dismissed it, but guess what? Losers will not let it go. They appealed to the higher appeal court, Ninth Circuit in California. And late last year, the Ninth Circuit said, whoa, judge, hold your horses. You don't get to decide that. It would be, they quote, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worthy of pictorial illustrations outside of the narrowest and most obvious limits." So at the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned of the new language in which the author spoke. So here, the judge said, while short phrases may not be protected, they could be protected under the Copyright Act if there's a much more creative nature to that lyric. And ultimately they said, you don't get to decide originality. It's up to we use the term trier of fact, and that could be a jury or that can be the judge at a full out trial and hearing the case and hearing the songs and hearing how it's used. So here we are faced with like this originality argument component. I haven't heard anything new about the case. It will probably settle. These things usually don't go the distance, but we'll see. I'm keeping an eye on it. If anything comes up, I'll report it. But we're talking about a one-phrase lyric in a song that a court is letting go to a trial to determine its originality. So I digress. That is part one on originality. I'm going to revisit the minimal level of creativity test with an expansion into using like Photoshop and other mechanical devices in the next component of originality.